engaging in an act.
Yeah.
As opposed to not engaging in an act.
So the whole.
I don't know.
No.
That surely has legal implications.
This articulates a really basic concept that I think we need to clarify. The idea of populating a contract is actually not what's happening. We will not populate a contract or a permit. It will verify an aspect of your identity as yes or no, right? So if we're all part of the Trust Federation and I'm Regulated Industries, and you, Doug, is applying for the permit, and you hold the information of he is a violent felon, he should be categorically barred, right? I ask you essentially through this Trust Federation, can Doug get a permit? Is he, a felon of whatever is not okay? And you say, yes, he is. I then go back and say, you can't get a permit, right? But let's say you say, no, it's not. There isn't a permit that then is filled in with information. I say, okay, here's your permit number, right? So I check an aspect of his identity, and then it allows me to issue him to act and give him a permit. There's no place where a form is auto-populated. Does that make sense?
It does.
I would actually.
It does, but I'm assuming you probably through phrase. My question still stands, although I understand exactly what you're saying. Maybe my phrase or population is not well. You have taken away the actual act.
So that's the legal significance.
Can I come in on this? I think that I would say the actual act is not filling out the form. That's not what's relevant. The actual act is applying for and receiving a permit. And it's the method, like filling out the form is just the method by which you achieve that. The actual civic act is still going on. It still requires the user, the individual who wants it, to engage with government. You just make it's almost like a cosmetic change at the level of filling in the terms. And the sort of proof of that is that when you go through this process, you are fundamentally agreeing to allow the city to access this information. So I would say that no, fundamentally it's not different. The user experience is very different, but the fundamental action of the citizen interacting with government is not different.
So that we take the affirmative act and fill it out and change it to the affirmative act. So you hit the button and you say, yeah, okay, check that part of my identity. And if we're worried about like a legal concept of like not lying on the permit, well, that's gone now because you can't. Theoretically, you wouldn't be able to lie because you're not providing the answer. The person who actually, the entity that actually has the information is providing it, and they're not going to lie. They're going to say yes or no.
I might be able to fill out some of this a little bit based on the underlying technologies and the basic understanding of the link between how they work and legal outcomes. And some of this is based upon that and in further extrapolation. So the underlying technology here, the operative one, is called OAuth 2. It's the one that allows when you hit a button to say like log in with Google, or hit a button that say allow Evernote to access my Dropbox folders. That authorization token that's specified in a technical standard. The standard's called OAuth 2, and that's what's being used here in OpenID Connect. Or OpenID Connect's built on OAuth 2. So at least my legal analysis, I think some of the standards groups was this is primarily focused at a life cycle moment in the transaction that is the moment of assent, or sometimes offering consent, or acknowledging notice, or authorizing something in a workflow or approval chain, for example. Those are the ways in which it works. And let's say those are business kind of moments. Legally, we believe that this is the very best moment to be looking at to create and preserve evidence of user actions and what they likely saw at the screen. So I kind of, like what you were saying, made a lot of sense. Like there's a lot of context in the overall process of filling the form out and thinking about the content. And there are ways to capture ever more evidence and log ever more things. In terms of like where we put a lot of stress and where we want to zero in and start having definitely effective techniques that can be commonly used, we select, many people, I guess now, have selected this moment of assent as being especially important. And so what they have here when this button is clicked is business, legal, and technical evidence of what's occurred. And so what's occurred now is this the legal moment when this person's executed a signature on a application. That's how that might look legally. I'd have to look at that again to see what it was, but that or executed a signature on a contract, or made an action to indicate that they are understand or they assent. And now what you need to do is tie that action to a user and tie that action to what it is that they were talking about, like the thing that they saw, for example, or where they were in an approval to spend money thing in an accounting process. The way that OAuth 2 does that, so that anyone could look back in log files to see what happened, or in the event of a dispute, have sufficient evidence to bring into court and have really good probative weight, is through encryption and tokenized and tokens that are exchanged back and forth with parties who themselves are under contract. And so that way, all of the parties, transactions, and the deal structure align, in my experience, way better than they frequently do when the systems are not tied to such sensible, well-architected network approaches as OAuth 2. Every endpoint is logged, and so you know every app, every permission, every party that had an app immediately, like with a click of one button, as opposed to a long exercise of discovering every third-party agreement and every trusted partner and every MOU you've ever signed can be actually very difficult. So our theory is that this makes the process of understanding one's legal relationships and also the authorizations under each relationship, in this case, like quite literally authorization to get this file, check that identity attribute, etc., easier to discover and define, and then also easier to manage approvals by individuals. So you'll note that everything here in this paradigm doesn't go kind of business to business and they report to you, every so often what they've done on your behalf. A lot of, like, for example, things happen in other industries where people proxy for you in financial sectors and others. They've got good systems, they could prove what happened, but you're mostly informed. OAuth 2, by contrast, is user-centered, and so all of the action, that nexus point, occurs when the individual makes an action. If they didn't click the button, audit logs ought to demonstrate that, and there's a problem here, and that's not been applied, and we will not get these expected legal results. It all hinges, the whole protocol and all the build-outs hinge on an individual taking an action and seeing something on a screen that correlates to a objectively determinable set of like what they saw in like a context of operations. What there remains to do is what Evan's beginning to do now. We've got great stuff that works at the social level where there's not much at stake. It's stuff that technically is quite sound and scalable. OpenID Connect makes it possible to put these in enterprise contexts. Now what we need legal departments, and we need risk management professionals, and we'll need compliance people and a lot of other folks to get their mitts on this and start making these consents say things that align with the actual contracts or the contracts that they would amend in view of this capability. So we get deeper alignment of the legal terms and the business terms, like who do I have acts with and so forth, and the technical terms to who has an OAuth 2 token. That's actually that's a doable problem now. Okay, I've spoken way too long. I apologize.
So nice, thank you.
I'm sorry.
No, you're fine. You're fine. Yes,
Just people don't know this.
Just kind of a
No, I know,
follow-up to that. Is there a verification process? So you apply for a liquor license. Is there? I understand all this data that's been gathered, and the application is filled out and stuff based on this data. But is there a verification process? Is there? I'm buying an article of clothing. Okay, and I'm buying it on a credit card. I ultimately see, before I click the final page, that everything is accurate. Sometimes
Almost like a treatment function. Yeah, just like.
I don't know what takes it.
The point is, somebody could be in a court of law, and all he or she will say is, yes, I clicked on that button. I didn't understand what the hell I was signing up to. That's the problem.
Well, that's what we hope to do. It's a generic problem signature.
Yeah.
If you look at the most rigorous work on that I know relates to patient consent. That's treated with much greater rigor and seriousness. And there's some work being done by state file networks in connection with the Apple research kit work. You see that but I think it's a generic model. Having practiced in both the U.S. and France, they treat it slightly more seriously in France than they treat it here. Here, it's really a serious problem.
Apple Kit doesn't actually encrypt the thing that the person signed with the signature, which is what I think is rarely called for here. It must be like what did they see on the screen, hash it and encrypt it with the signature, so there's no question exactly what they saw. It would be, I think, it's responsible for asking.
What Will
We should
Banks
add that.
what Will Banks and the Sage guys
We can add that.
is the whole video experience.
Yeah. So, any questions about teams 1, 2, or 3? Just make sure we've got time for that. No, hearing none, as they say. Okay. I think we'll turn over now to Professor Ian for a final wrap-up.
I asked Michael if I could just say a few words at the end, mostly because as I was in Boston in November, I'm just kind of in awe of what's happened here. And I wanted to say this. First of all, we are, UMKC, an educational institution. And so it's with great pride that I just watched our students do such a terrific job. I mean, it's just.
And before none of this would have happened, if we didn't have a team committed to this in the law school, then they wanted to experiment. This is really very much an experiment. As I mentioned yesterday to those who were here, Bowser asked me about it in mid-August. Late August, we had a course, which is phenomenal at the university, and that's largely because of the dean's leadership and Michael pieces together. And then everybody you heard about today who has collaborated with us, all the organizations, companies, individuals, for free. This is all contributed time, a lot of it, which means to me, when you add that to the audience that gave us feedback yesterday, that Michael and I were amazed at how much of the feedback got incorporated in such a short time in this project. Folks, lawyers, non-lawyers, engineers, technologists, folks from across the U.S. and London, it's been a terrific thing, creating the thing over the 2 semesters we've now done this, and learning the largest and Gaza how to do this kind of prototype. What I think Tony and I would call a really interesting community, right? An interesting community of folks passionate about law, technology, and public policy and the intersections thereof. And yes, we can help you debate about all of this, and it's terrific. So, since I grew up in New England, my parents were around Boston, as I said at the end of the prototype here in November, the only way I know how to characterize what's happened here is this has been wicked. And so, I parting words on people's mistake when there's a lot of discussion, but to formally close the program, I'd like you to join me in applauding wicked.
So I will say that there is a little bit of dessert still out there, so anybody who likes something, feel free to go ahead and get it. We don't have any rush to be out here. Those of you who are going to the opening of the conference, as my understanding of the section, you can do the last at 5. So you have plenty of time to get over there. And you go ahead and have a couple of students who have to and then you can and we appreciate those who are early on to be part of this because the more set of eyes
One of a kind.
Everything's horrible on the way before the 8th. But then I'm there. So like, if you take it on 11, 12, virtually. Okay, this is like what we do. That and then. Yeah, I think that was about like, yeah. Yeah, the other thing that I wanted to, I kind of feel like I'm Okay, yeah, that's not true. Okay. All right, thank you again. Oh, yeah, that was well, you would have more. Yeah. Okay. Okay. Yeah. Right. Yeah, right. So if you apply because yeah, okay. And if I really